We're with Ryan Tegnelia. Ryan is a criminal defense attorney in San Diego, California, and he's agreed to answer some online questions. These specifically are related to violent crimes. With that said, Ryan, let's get into the first question. First question was from Kevin. If I'm convicted of a violent crime, do I need to go to jail, or do I have to go to jail?
Well, that's a good question, Kevin. Whether or not you end up actually doing custody time depends on the level of the offense that you're charged with, as well as your criminal history and the nature of the victim. Violent crimes covers any crime basically that occurs between one person and another person, so anything other than property. It ranges broadly from simply threatening somebody where there's no actual harm to severely hurting someone. And obviously, based on the level of injuries, if there are any, and the nature of the conduct really determines whether or not you're looking at the possibility of jail time. That being said, if your criminal history and background are good, a good attorney is usually able to avoid any actual custodial sanction.
Okay, excellent. Next question was from Daniel. Daniel asked, how long is someone looking for at an armed robbery of a convenience store?
Well, armed robbery, it sort of depends on what you're armed with. Generally speaking, the maximum punishment on a robbery offense is about 5 years. That's the maximum prison term. But they add time depending on what kind of weapon you're using. So if it's a knife, then there's an enhancement for that. If there's a gun, then there's an enhancement for that. And then depending on whether or not you actually use the weapon. So there's a difference between robbery where you simply possess a gun and then robbery where you actually discharge the firearm. And it ranges anywhere, from adding anywhere from 10 years to possibly lifetime.
Gotcha. Next question was from Sonya. Sonya asked, my husband is being accused of murder and is in jail right now. They have not set his bond. What can I do, and do I have any options?
Well, at least in California, you have a state constitutional right to bail. So the judge will set bail on your husband's case. If it's not set there yet, it's probably just because the sheriff's website is updating and he's freshly booked in. Standard bail for murder in at least San Diego County is $1 million. So step number one is, since he's in custody, he will have to be produced in front of a judge within 72 court hours. And at that time, that will be your first opportunity to address bail. And so generally speaking, on bigger crimes like murder, it's beneficial to you to contact an attorney and sit down and talk to them prior to his first court date, because that is the first time that the judge will be able to address bail. But I can tell you that it's highly unusual for people to bail out when facing charges of murder. Okay,
next question we had is, my son is charged with assault with a deadly weapon for his involvement in a bar fight, but there was no weapon. How can he be charged with assault with a deadly weapon if there was no weapon?
Okay. This is actually one of the most common questions we get, and it is a little bit confusing. Penal Code Section 245 is the standard felonious assault statute. So if the person is hurt enough where there was a felonious level of injury as opposed to, say, misdemeanor battery, you'll be charged with what's called a 245. The title of the statute and the way it reads is assault with a deadly weapon or force likely to cause great bodily injury. So because assault with a deadly weapon comes first and it kind of rolls off people's tongues well, that's how it's generally referred. But it also includes violent crimes where someone is injured or there's force used that would likely cause great bodily injury that does not involve a weapon. So if there was a bar fight and somebody was hurt or had suffered a level of injury that would arise to the level of a felony, and your husband was charged with a 245, that is the correct statute.
Okay, and the final question we had was from Jonathan. Jonathan asked, I'm charged with a felony assault after a bar fight downtown, but I didn't start the fight. Why am I being charged?
Oh, well, thanks, Jonathan. That's actually one of the more common questions. San Diego, we get a lot of these cases where we have bar fights that are then turned into what are usually 245s, like I just explained. Obviously, we're a big tourist town, a big destination town. People come here to party and have a good time, and sometimes violent altercations result. As a general rule, the district attorney's office, when evaluating whether or not to charge someone with the crime, they pay less attention to who started it as opposed to who ended up winning. Generally speaking, the winner of a bar fight becomes the defendant. So even if you didn't start it, but you really hurt the other person, they're still going to charge you with a crime. How much it's going to cost to defend that depends. It depends on the level of injury, because again, that's going to determine whether or not it's going to be charged as a misdemeanor or a felony. It depends on what level of the case, or I'm sorry, what stage of the case you contact my office at, whether it's before it goes to court or in the middle of it. And then it depends on whether or not you need to go to trial, as many of these cases do. The vast majority of criminal cases do not result in a jury trial. So we tell people to be wary of attorneys that charge a higher fee, but then claim that the jury trial is included, because oftentimes what they're doing is they're charging you for a service they know you're not going to need. So we prefer to sit down, talk to you about the facts of your case, what your expectations and goals are as far as your defense, so we can determine what the best price is for you. And then, of course, we do also offer payment plans.
Excellent. Well, if you have any other questions for Ryan, all you need to do is post them in the comments section below. He's agreed to answer the comments to the YouTube videos. With that said, thanks for your time, Ryan.
Yeah, thank you, Ryan. And anybody, if you're facing any of these types of charges or situations, please give us a call, 619-577-0868. Consultation's free. We're more than happy to sit down and just discuss your case with you and at least give you some direction heading forward, as we know this can be very confusing. But thanks again, Ryan. I'll see you for the next one.